Hi everybody, this is going to be my legal assistant, Hadley Ray. Okay, so this is our case, Keys versus School District number 1. It's case citation 413 U.S. 189. This was decided by the Supreme Court on June 21st, 1973. So background facts. If some schools are racially segregated, does that mean the district they operate under is segregated? This issue arose in 1969 in Denver public school systems, which educated around 100,000 students with 119 schools. The school district was tri-ethnic, consisting of white, black, and Hispanic students. The school built a new elementary school, which was Park Hill Elementary, in a predominantly black neighborhood. Due to gerrymandering school zones, optional zones, and excessive use of mobile classroom units, this resulted in Park Hill being attended primarily by black students. Keys, a district parent classroom, sued on allegations that the school district was segregated. The district court found that the school board actions had led to unlawful segregation in Park Hill schools, but Keys had to prove that Denver school system established segregative practices throughout the district before ordering desegregation in other parts of Denver. Remember from Brown versus Board 2, the Supreme Court said that they were going to leave that decision to the lower courts. Keys appealed to the 10th Circuit Court of Appeals, and then they affirmed the lower court decision, so they agreed with the lower court. And then Keys appeared to the Supreme Court of the United States, and that's where they granted cert. Alright, so the issue. Did the segregation in Denver involve all the city schools and violate the Equal Protection Clause of the 14th Amendment? So, the decision of the court was 7-1 for Keys. The court modified and remanded the lower court's decision and held that when part of a school system is found to be segregated, a prima facie, I don't know Latin, get out of here, all right? The first impression case of unlawful systematic segregative design becomes apparent. The school district involved assumes the burden of proving that it operated without segregative intent. On a system-wide basis, this case is significant because it represents one of the first instances in which the court identified segregation in northern schools. Okay, now the opinions of the court. So the majority opinion was by Justice William Brennan. He ruled against the Denver District Authority and held, whereas in this case a policy of intentional segregation has been proved with respect to a significant portion of the school system, the burden is on the school authorities, regardless of claims with their neighborhood school policy, was racially neutral. To prove that their actions as to other segregated schools in the system were not likewise motivated by a segregative intent, the evidence of segregation in the Denver School District was determined to be such significance that it implicated the entire district school system as a result. Whereas most of the segregation was a result of a de facto nature for 10 years, the majority opinion held if the actions of school authorities were to any degree motivated by segregative intent, and the segregation resulting from those actions continue to exist, the fact of remoteness in time certainly does not make these actions any less intentional. As far as the dissenting opinion, Justice Rehnquist and in part Justice Powell, he agreed, kind of didn't agree, he was separate. Justice White did, and then Justice White, they did not decide if this case or Justice White did not make a decision towards this case. As you know that there's 9 members and it was a 7-1 decision. Justice Rehnquist believed the court transgresses the 2-court system and did not require SCOTUS decision, but only ruling on whether the lower court applied correct legal standards in deciding this case, as it affects the core city schools. Justice Berger and Justice Douglas, they delivered the concurring opinion. They authored separate opinion believing there is no difference between the de facto as what really happened and the de jure, which is what the law says should happen, segregation. Douglas believed that the state board was a state agency and the drawn districts, locations for schools, allegations of students, and budget are all state action for the 14th Amendment purpose. So this is why I look at it. I do not believe there's a difference in a de facto or de jure in this case. If the school system appears to be segregated, then it is in fact segregated. This does not fall under what previously stated in last week's cases where it says, I know it when I see it. But lipstick on a pig is lipstick on a pig. There may have been 119 schools, but if some are stacked to reflect a specific race and have token members to appearance that is minimal inclusivity, hey, whoa, all right, you're just a paralegal right now, all right, and continues to allow a sense of superiority, I think it would be interesting to expose interested to explore the economic status of the Park Hill School and compare it to schools that were all white at the time. All right, so this is our case for this week. I will sign them as needed.